Did a guy named Kenneth Probus in a case remarkably similar to this one a few years ago, which turned out completely differently here. Kenneth Probus, a suspected drug house. He's sleeping in his bed. Police bust in the door. He shoots, I believe, at least one police officer. Police fire back and shoot him. He gets charged with attempted murder. He ends up getting 7 years. Kind of the opposite situation in this. Talk about the similarities or lack thereof in these two cases and how they've turned out so differently.
Well, I think the similarity is that we need, as a city and a society, to look at these no-knock warrants because they're ending violently. My client was asleep, Kenneth Probus was asleep in his bed, and police barged in. They say they announced. My client never heard anything. He was asleep. There was never any connection with drugs to my client. He had a roommate that was minorly involved in drugs and no reason to bust into his house. And he was shot multiple times and injured and stayed in prison injured, and we end up settling for much less than what he was charged with, but he did take a felony conviction based on our negotiations with the prosecutor. That case did not receive 1/100th of the attention from the nation and the community, and there are certain circumstances and certain reasons for that, but it was a very similar occurrence of police busting in, busting a door down, and then shots being exchanged, and the officer was grazed, and my client was almost killed.
Leland, let me ask you, so in this case, it's taken a long time because we didn't have any body cam footage to know what happened, so very different than the George Floyd case that we followed in Minneapolis. Daniel Cameron, the Attorney General, had been saying that he needs ballistics. He's waiting for ballistics, and then he said he finally got it, and this is a critical piece of the investigation. What do you think it is exactly that they were trying to determine with that?
Well, I think the ballistics, again, without knowing what they showed, I think they could show what guns fired which bullets and which of those bullets struck Miss Taylor and then Sergeant Mattingly. And they can also tell, depending on the ballistics, the trajectory of the gun, what angle they were fired from, what distance they were fired from. So this seems like a case where they were wanting more information or as much information as possible to make a decision that they could stand behind, because typically cases are presented to the grand jury, even shootings, in 4 or 5 days or with much less information. So the fact they took these extra steps shows that they were either looking for more evidence or wanted to have as much as possible before presenting it to the grand jury.
So we did speak about Brett Hankinson. So if it's determined that his bullet was not the one, did not hit Breonna Taylor, then it would just be wanton endangerment charge.
Most likely. There's a theory of complicity where when one person is in an act and these people are acting together in a scheme, that's typically where you have like a bank robbery, where one person shoots a clerk and the other two don't, but they all escape with the money. They're all charged with robbery in the first degree. I don't see this as that exact kind of situation, but there's potential for that.
I have a question.